You're welcome to my channel. In this video we are going to be handling the conduct, procedure, attendance and quorum of shareholders meetings and the management of a company in company law or business law too. In our previous video we talked about meetings through which shareholders manage the company, and there were 4 meetings, and that is the statutory meeting, the annual general meeting, the extraordinary annual general meeting, and then the meeting convened under court order. We shall start with duration of notice of a meeting. And every company's meeting must be convened by a notice given to all those who are entitled to attend and vote 21 days before the meeting. Failure to give notice to a person entitled to receive the notice, it renders any business that is discussed in that meeting void, unless the Articles of Association provide otherwise. And this is under Section 140 of the Companies Act. Let's look at the nature of the notes of the meeting. The notes of the meeting must be in writing, and this is according to Section 140, Part 2 of the Companies Act, and the notes must disclose all the matters to be discussed at the meeting. And this was seen in the case of Bailey versus Oriental Telephone Electric Company Limited in 1915. Chancery Division 503. The Court of Appeal agreed on the basis that the notes in the issue did not give sufficiently full and frank disclosure to the shareholder of the facts upon which they were asked to vote, and therefore the resolutions that were made during the meeting were not binding. So the notes must disclose all the matters to be discussed at the meeting, and if all the matters are not disclosed, they consider everything that was discussed during that meeting void. Then let's look at the quorum in meetings. Quorum refers to the minimum number of persons required to attend a meeting before business can be transacted. Usually quorum is regulated by the company's Articles of Association, which is AOA, but where they are silent, the law states that for private companies, 2 members present in person is sufficient to hold a meeting. Then for public companies, 3 members personally present is sufficient, and this is according to Section 141, Part C of the Companies Act. Let's look at the duty of a chairman. A chairman is that person who is always in charge of the meeting. It can either be a chairman or a chairperson. The chairperson of the meeting may be elected by the members present at the meeting, and this is under Section 141, Part D of the Companies Act. The Articles of Association usually stipulate who shall be the chairman at meetings. For instance, in Table A, under Articles 55 to 56, indicate that the chairman of the board of directors, if present and willing, shall be the chair at the meeting. But if he or she is absent and the members wish so, a chair may be elected by the members present among themselves. And the duties of the chairman include ensuring proper and orderly conduct of business at the meeting, regulating the proceedings, and then keeping time. Article 60 of Table A gives the chairman a second vote or a casting vote at the meeting where the votes are equal. And in the case of National Dwelling Society in 1894, Chancery Division 159, the court held that it's the duty of the chairman to take care of the proceedings at the meetings and preserve order. Let's look at voting in meetings. Generally speaking, each member has 1 vote by show of hands, irrespective of the number of shares held by him or her. And this is according to Section 141, Part E of the Companies Act. And voting may be done either personally or by proxy. Proxy means voting on behalf of someone. Let's look at proxy. A proxy in company law is a document which authorizes somebody to attend a meeting on behalf of a shareholder. And the appointed person may or may not be a shareholder. The right to appoint a proxy only applies to companies having share capital. And under Section 143, A person holding a proxy can vote on poll unless the Articles of Association disallows it. A member of a private company is not allowed to have more than one proxy on the same meeting. A proxy may be revoked or disregarded before it has been acted upon by the company or by the members attending or voting in person. And lastly, the notes calling the meeting must specify that members are free to appoint a proxy, and this is under Section 143, Part 3 of the Companies Act. Let's look at voting by poll, where the articles provide that voting shall be by poll. In a company with share capital, each member has one vote in respect of his shares, and that's what we call voting by poll, one vote in respect of each of his shares. Thus, a shareholder with a higher number of shares has a higher vote. And under Section 144, a poll may either be demanded before or by show of hands. Let's look at company minutes. Company minutes are documents that show what transpired in the previous meeting. And it's intended to remind people of what transpired in the meeting and update those who didn't attend the meeting. Every company must have minutes of all the proceedings of its general meetings and meetings of the directors. Such minutes, once signed by the chairperson of the meeting, shall be evidence of the proceedings of the meeting, and the meeting shall be taken to have been duly held and convened. And this is under Section 152 of the Companies Act. And failure to take these minutes creates liability for every officer in default of a fine of 25 currency points. And that was all about the conduct, procedure, attendance, and quorum of shareholder meetings under management of a company. Thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about the board of directors.